were saying that, yes, this is not novel, but what?
It is not novel, but I was indicating by way of a general context that what is novel about it, as far as I remember, but I don't think there's precedent of a predecessor in office taking on a successor in office, not by way of the way he was removed, but by way of, or by reason of challenges he has about how the successor is performing the duties of his office. So, that part is novel. That part I can't remember there's precedent too. But it's important in terms of the substantive issues for us to remember by way of foundation that the mandate of the Office of the Special Prosecutor includes a public engagement. And so that public engagement component of his work invariably will involve him doing things that may ordinarily be out of convention. It is not conventional, by way of standard practice, to have a lawyer go to court and then after court have complaints about how the justice was administered, especially not just a lawyer, but a public officer lawyer, so to speak. And therefore, if you look at the petition of the petitioner, he specifically refers to the fact that if it was a DPP, he could have been someone that perhaps dismissed. And that is true, possibly. And the reason is because there are ethical constraints on how we do our work, particularly as lawyers, in reference to the judiciary. However, in the context of the Office of the Special Prosecutor, things are a bit nuanced. And I think it's imperative that we understand it from that nuanced perspective. He has a public engagement aspect of his work. The question of whether or not he has done his work in a manner consistent with what the law expects, as far as the public engagement part is concerned, is an issue that is open to debate. And I'm not going to make any definitive statements because this is a matter that is unfolding, that is about to be investigated, and the processes are still ongoing. So we need to respect that aspect as well and not make statements that may appear to be publicly prejudicial. So my statements are just general and open-ended for educative purposes. And the point I'm making, particularly in this context, is the fact that if you look at the law that establishes the Office of the Special Prosecutor, the law itself is framed around the 1992 Constitution in terms of the similarity of the offense or the circumstances under which the Office of the Special Prosecutor could be impeached. So Article 146 of the Constitution, for example, establishes the framework for impeaching judges. And the words that were used, among others, stated misbehavior or incompetence. The same rendition has been repeated in the law establishing the Office of the Special Prosecutor, in which the OSP can be removed on grounds of stated misbehavior or incompetence. Notably, however, both the Constitution and the OSP Act do not define what constitutes stated misbehavior. Incompetence, we can assume that we probably would recognize what incompetence is if we see one. But stated misbehavior presupposes that there are constituent aspects of what can be considered a misbehavior. However, because the two laws do not define it, the Constitution doesn't define it, so we can't make reference to that, and the Act also doesn't define it, it means that the one making a determination by way of the impeachment, the panel making the determination, will have to decide that a particular act meets that threshold of stated misbehavior. The question is whether acts that are considered just professionally objectionable, whether these acts will meet that threshold, or whether you need specific acts that go beyond just professional misbehavior to constitute an act of stated misbehavior. These are things, again, as I indicated, the law hasn't been tested in that respect, in terms of what constitutes stated misbehavior. If a lawyer does something, if a professional, if a public servant does something in the context of his office, whether that would be an act of stated misbehavior or just any act we find professionally objectionable. So an act that you may find professionally objectionable could be an act of holding a press conference, for example, and complaining about what judges, may have said or done while in the performance of their work. Whether beyond that, that constitutes an act of stated misbehavior is still one very much in the air, in my opinion. We haven't defined that, and we haven't ascertained that.
Prof, whilst we have you, and one issue that is coming up, debate among lawyers, and I have done an article 146 process before, which led to the removal of Loretta Lante from Shraj, and I also took up led Kofi Abotsi to the Supreme Court to seek to challenge the removal of Charlotte Osei. unsuccessfully. But the issue that is coming up now is, first, the CJ writes to Kissie Jabing and say, bring your comment for me to make a prima facie determination. Some lawyers say you don't need Kissie Jabing to provide you anything to do the prima facie determination. And to some extent, if it is a bare allegation without more, it is the respondent that you are asking to try to supply evidence to help someone who may be into fishing. What do you say? They say she should just look in front of on the face of the documents and make a determination rather than asking for a reaction.
Well, the fact that the law doesn't require something doesn't imply that you cannot do it. What you cannot do is what the law expressly forbids. So if the law expressly says you can't do X, then you can't do X. If the law doesn't say you can't do X, it simply means it is not a requirement, but it's a general permission. So if it's a general permission, you can do that. So the point I'm making is, by standard practice, the determination of the prima facie form, and understanding the context of the OSP Act, does not require necessarily the input. But that non-requirement is not itself a prohibition. And so Chief Justice wants to satisfy herself that my determination of a prima facie having established is without, because a prima facie case established, one has to satisfy himself or herself in this context that certain minimum elements or features of the offense have been made. And those minimum elements, ingredients of the offense itself, require certain minimum threshold proof, which is that the one big step would have to satisfy herself that those elements have been made out do not have verified that challenge that premise. So the point I make is to avoid perhaps any left the realm of doubt, even at the final stage. The CJ Act.
Your students have a question for you, that when you define prima facie to them, they don't understand it in the manner we are seeking to create this precedent for a determination of a prima facie. If you picked the Oxford Law Dictionary, any one of them, it will simply tell you that prima facie means whatever it is you are holding, you look on the face of it and make a determination. So why do you need facts from the opposing side to make that determination? That's the question they're asking.
Absolutely. On the face of it simply means on the face of it. But the point I'm making to you is, even on the face of it, there may be statements that challenges your own assumptions and hunches on the basis of what you're reading. I'm trying so hard so we do not complicate this. Do not forget the fact that as you read a document, you are forming hunches, you are forming opinions, you are drawing conclusions, you are making extrapolations, you are making deductions. All these are things that the mind, all these are cycles and processes the mind goes through as you are reading something. On the face of it, constitutes your judgment of what you get or glean from what you read on the document. Now, the point I'm making is, if the law doesn't forbid, it means that one can do it even as a surplusage or as an extra mile. So my understanding, and again, this is me second guessing, the Honorable Lady Chief Justice on this. My understanding is perhaps she just wants to show that she doesn't contradict or she doesn't make a determination that some hunches or some judgments or some opinions she may have formed at this stage may themselves be subject to some erroneous conclusions, and therefore she's going the extra mile, even making a determination at the face of it. She's going the extra mile of giving the option to.
So, as someone who is very familiar with this kind of matters, and I remember when Richard Nyama filed his petition to the president, it was forwarded to the Chief Justice, Georgina Wood. She also required the Shraj boss to make comments. So it's a precedent. When the one about Charlotte Osei came up and her deputies, they were required to make their views. But this is one aspect that I will lead you a certain way, where I sought to challenge that kind of thing in the Supreme Court. Does it And for example, in the first one that I did, there were several petitions, but only one petition was deemed to be competent and used. Must it take the respondent, Kissie Jabing, to tell the CJ who must make a determination of prima facie that if you look at Section 75 of the Office of the Special Prosecutor Act, general immunity, an authorized officer is personally immune from civil liabilities in the performance of duties under this act if the authorized officer acted in good faith and on reasonable grounds. Remember, they have the powers of police according to the law. So just like judges also, in Article 127, Clause 3, a justice of the Superior Court or any person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of their judicial power. My question is, if you say they have breached people's rights by arrests, take that against the immunity they enjoy. Should it take Kissie Jabing to tell the CJ that this is my defense, so throw that issue out?
Again, Samson, I can understand the context in which you make your point, because the truth of the matter is, in standard legal practice, a person is called to open his defense only after he's raised an objection against there being no case, and the court has heard the objection, and the court basically has said, there's a case to be answered, open your defense. So I can understand what you're saying. Ordinarily, the respondent or the response is taken only after a preliminary determination that there's a case, go ahead and respond to it. So I can understand that. But again, this is a peculiar terrain.
Okay.
You have a petition brought against a public officer, and then you have the Chief Justice as an individual to make determination of whether she thinks that there's enough case made on the basis of which the respondent should open his defense, or he has to open a defense to the petition that has been brought. The point I'm making is the Chief Justice is not forbidden in deciding whether or not to indicate that there's a prima facie case made. She's not forbidden, in my estimation, from hearing the other side before she makes it. It appears to be an extra mile that she's done, but the law doesn't forbid that being done.
Right.
And we can't put this in the same straitjacket that we put criminal cases in which a defense is only asked to.
The next issue around that is, will all of this not be resolved if there were constitutional instruments or regulations about how to exercise this kind of power in respect of Article 296? And in a J-Chum versus the Attorney General, this is what Justice Sufai Akufu said. I quote, "However, I wish to express my misgivings and discomfiture arising from the absence of any consequential enactments which regulate the removal of justices of the Superior Court, and in particular, any detailed rules of procedure for the performance of such an important process as the removal of the Chief Justice of the nation. The provisions of Article 146 sketch out in broad strokes the basic procedures for the commencing and carrying out the process for the removal of justices of the Superior Courts and the Chief Justice. And as aptly noted by my brother Professor Okran in his concurring opinion hearing, essential details such as the form of the petition have been left out. Also left vague and unclear are other essential matters such as the procedure to be followed by the committee in the performance of its assignment. This is only as may be expected, since the Constitution is not intended to provide details and procedural guidelines, but rather to establish a framework of the fundamental values and standards upon which substantive and procedural legislation may be and are expected to be built for good governance of the Republic, is making rules. And she said other things, but for want of time, I don't want to go there. The issue about misbehaviour, what constitutes it? She spoke about it. The Supreme Court spoke about it at the time. Is this the way to avoid some of these?
No, I mean, I 100% agree with the fact that the detailing of rules always help clarify gray areas, twilight areas, and any prospect of confusion. So that would have been a very good way of resolving this. Indeed, Article 296 clearly spells out the fact that where the exercise of discretionary authority is by a judge, it has to be based on a constitutional instrument, on the basis of which certain details will have to be given and spelled out to avoid all these confusions. So I do fully agree with you on the fact that maybe all these speculations and uncertainties could have been resolved if the matter had been better clarified by way of a constitutional instrument. You mentioned that the judges about what constitutes status is, but it still remains an open-ended area, an open-ended situation in which we do not put the constitutive of stated behavior when allegations are become. And the constitution itself says in Article 1511 that where anything constitutional, and in this case, because of the harsh application of it, where anything constitutes the things are spoken unless it is very spelled out as penalty. So all concepts that complicate things, especially when it gets or penalty concepts that should follow an act deemed an act of.
Your line is getting bad again, but I'll try my very final question to you, Prof. Section 15 says that when the President receives the petition, he's supposed to forward it to the Chief Justice within 7 days. So for those of you who are going on with the mischief that the President did it so swiftly and there have been petitions that he has never forwarded, those were under Article 146, where there's no timeline to forward the petition and so on. And presidents have abused it over the period. You send the petition, they won't forward it because the person you want to remove, they don't want the person removed. Now, this one says he should forward it within 7 days. Then the Chief Justice, within 30 days, must make the prima facie determination. And then when the committee is set up, within 14 days, they must bring their recommendations to the Chief Justice, which he will forward to the President, and the President has no discretion in it. He simply has to implement the decision. The question is this one. The person supposed to constitute the committee if a prima facie determination is made. One, a justice of the Supreme Court. Questions are arising. There is the perception already that the judiciary is not happy with the OSP. A justice of the Supreme Court. B, a lawyer of not less than 15 years standing at the bar. And then C, the third person should be a person who has expertise in investigation. The question is, OSP, IOCO, having problems, theft wars. OSP is investigating the police on police recruitment scams, and there have been bad blood, as we understand, between the OSP's office and the police because they are making this investigation. So if you need a justice of the Supreme Court, then you need a person with expertise in investigation, most likely to come from either the police, IOCO, or one of these security agencies. What happens to the rule of natural justice?
Okay, so let me deal first of all with the law, and then let me deal with the perception. By the law and by the decision of Ghanaian courts, even where you have issues with the courts will still have to determine it, and the court will have to still constitute it. Remember the decision in Ekufuor and Kwashaidan, in which the matter arose as to whether the Chief Justice could empanel or could put together a panel to make a determination in a matter in which the Chief Justice himself has been sued. And the court came to the conclusion that the Chief Justice in performing that mandate was performing an administrative task. It has nothing to do with his office as a judge. And so, that's the law, unfortunately, in the sense that those who have issues against it, we can only express concerns, but you can't, it's the law. The position of the law is it still remains the mandate of the judiciary to put together the administrative incidents of justice. And you cannot complain or you cannot object against it the way it is. So that's the law. But obviously there's a perception part. And that perception part is justice itself also survives on perception. In fact, the saying goes that justice must not only be done, but it must be visibly seen to be done. And so in this case, we clearly cannot also disregard the perceptual aspect of things. The fact that those who are subject to the administration of justice would have their own perceptual view of things. So I would hope and believe that steps will be taken, in empaneling and putting together a body to determine this matter. Steps will be taken to ensure that those perceptual difficulties are dealt with. The various institutions whose mandate and whose operational behavioral tendencies have involved them and the OSP in a conflict situation. All those will have to be taken into account so that perhaps if the OSP has objections, and if he raises objections about the Constitution, perhaps those who have to be given serious hearings and feedback, just so we deal with the perceptual aspect. But as I indicated, the law has stated the constitution of the panel, the law has stated how the empanelment should be done, and those are the law. Nothing can be done about it.
Thank you very much for your time this morning, Professor Kofi Abotsi.